Welcome to the India Development Debate. I'm Tamanna Inamdar, and it's been quite a day for corporate India. Both Tata Sons and Infosys have been in the news today on questions of corporate governance and the rights of minority shareholders. In the case of Tata Sons, relief came in from the Supreme Court that stayed an NCLAT order reinstalling Salil Mistry as chairman of Tata Sons. The real fight, though, will remain over Mistry getting back his seat on the board, and that is yet to come. Infosys released its quarterly numbers today and importantly put out its probe report on whistleblower complaints against CEO Salil Parikh, giving him a complete clean chit. It was the second whistleblower complaint Infy has had to deal with famously, and a second clean chit with its own probe. In both these cases, the spotlight is on how these mega companies have conducted themselves. And helping us look at the bigger issues is corporate guru Prabal Basu Roy, who joins us now. Prabal, welcome to the show, and thank you for speaking with us. Give us some perspective. Let's start now with the Tata case and what we've seen today. Salil Mistry has made it clear that he does not want to take back his previous role, and the fight is for his seat on the board and his rights as a minority shareholder. Do you see larger implications?
Thanks, Tamanna. Thanks for having me. See, on the Tata Mistry case, if you cut out the ambient noise, there are basically three big issues, and which I think the Supreme Court will look at. There are three big issues. The first one is rights as a professional CEO. Now, for that, the route, and someone who's been wrongly terminated, right? So that part, I think, is part of the civil suits route. It does not come through NCLAT, frankly. I think it is ultra-virus in that sense. The second one is to do with minority rights. That's within the section 241 to 43 of the Companies Act, etc. And there are two issues, essentially. Two sub-issues, and one can be a separate one. The first one is the rights of the minority shareholder to good governance of a listed entity, or of a, in this case, not a listed entity, but a clutch of listed entities. So rights to good governance, which includes rights to information, transparency, good decision-making, etc., all of that. Now, on that part, that is what hits at this shareholder democracy part of the thing. Now, the board, as long as the board takes a decision in the right manner, there is no issue with this. And shareholder democracy will survive and will proceed. But the problem is that there is this concept of a super director in many companies, and that is the way boards are being effectively run, where the directions come from someone who is not part of the board. So that is the minority shareholder side, which will have to get taken care of in this particular judgment. The third one, Tamanna, though, is something which has not been spoken about too much in the public domain, and I would like to bring it to the table today, is the right to property. And that's a constitutional right, by the way. It is also linked to minority rights, but it is also a constitutional right. Please reflect on this. You know, the articles of Tata Sons actually say that the board can buy out any minority shareholder, which is Mistry in this case, can buy out at any time and at a price determined by the board. And this pricing is done in case of Tata Sons once a year. And just between, just for the record, the pricing is done on a very conservative basis by very eminent people, etc. So last time I calculated the TCS value, the total TCS value of the holding is all that is reflected in the Tata Sons valuation. All the other companies are practically at zero value. So the point is, if this is the sort of pricing and the coercive clause which exists, which is against the Constitution because it's my property. So that is something which I think Mistry is really fighting for, and the Supreme Court will probably be very well placed to pass a judgment on this. So these are the three larger issues as I see it, three completely different issues, and I'm sure the Supreme Court will see what happens.
Just quickly get perspective from you on the other big story we've been tracking here today, which is Infosys and the clean chit which has been given. Now, once again, it's an internal audit committee, and the allegations were pretty serious. Do you think there is a need to look at any kind of external, audit on situations like this, Or do you think that, those who watch this company very carefully, like yourself, are satisfied with what Nandan has said today?
See, now this is a tricky issue because, and I've sort of written about this earlier as well. Now, I have no reason to doubt anything which either the board is doing or under the leadership of Nandan is doing, because they have handled, and he has personally handled this very well in the past. I mean, given his reputation and all of that. But the fact of the matter is that, see, in the whistleblower's letter, there were essentially two large issues. First was to do with the integrity of the accounting practices, right, and financial statements. And within that, the first was on policy deviations and changes in internal controls, and the second one was to do with improper recognition of costs and revenue. This was the big ticket item. The first one, I mean, it's a management decision how you want to play your internal controls and what you do with large bid reviews and policy deviations. So that's not something which, you and I can comment on. But the improper recognition of costs and revenue, to the extent that it affects the financial statements, is a matter of law. And that is somewhere where auditors, audit committee, board, everyone gets implicated. And I think whatever they have done now, and they have sort of said that there is no impropriety in these matters, that should settle matters to a large extent, because auditors, I'm sure, were involved as well. Now, how far do you go outside and take other people? Yeah, that's a good. But the good thing here is, good from an investor perspective, is that the matter will not end here, though. Do appreciate that the SEC is doing its own investigation, SEC in the US, and they are as stringent as it gets in terms of...
It's the SEC in the US.
Yes.
It's the SEC in the US doing the investigation that...
Correct. Yes. So that is the external viewpoint which can come after a while.
Yeah.
So I think, by and large, I think I would trust the Nandan particularly and the Infosys Board.
Right.
But there is an external viewpoint which will come in few months' time. Yes.
Absolutely. Thank you so much, Prabal. Pleasure as always to speak with you and get your perspective on two very big corporate stories today.